Warning, we are not your attorneys. Please, don't take anything we say as legal advice. I'm Jeff.
I'm Mike,
And I'm Derek,
and you are listening to the Not So Grand Jury.
which is now sponsored by Morwa P. LLC.
So, Runaway Jury. Not The Runaway Jury, but Runaway Jury. Based on the novel by John Grisham, I think his best-selling novel of the 1990s, concerns a trial in which a widow sues a gun manufacturer who made the gun that killed her husband in an office workplace shooting. And the central plot revolves around a jury consultant played by Gene Hackman, who is attempting to rig the jury through various means of varying ridiculousness that we'll get to. And spoiler alert, ultimately he is unsuccessful because while he is trying to fix the jury from outside as a jury consultant, John Cusack's character, John Cusack, who plays one of the jurors, manipulated the system to get on the jury and is manipulating them from within. And ultimately, the jury finds in favor of the widow, holding the gun manufacturer accountable for a huge sum of money. So, we talked in a previous episode about jury consultants. I think it's come up in both The Lincoln Lawyer and was it one of the King of the Hill episodes? We just talked about jury consultants or jury tampering in Daredevil. That's what it was.
Oh, yeah. Jury tampering is one of our common tropes.
Yes, and we're going to get there
Yeah.
in this conversation, most certainly. So I want to give a little bit of a background in what is a jury consultant, what is jury tampering, what are the distinctions, and then we can talk about kind of how this applies to what all the characters get up to in the movie. So jury tampering, this as with many John Grisham books, this takes place in Louisiana, and Louisiana, like all states, has a statute prohibiting jury tampering. It defines jury tampering as any verbal or written communication or attempted communication, whether direct or indirect, made to any juror in a civil or criminal case, including both grand and petite jurors, or petit, for the purpose of influencing the juror in respect to his verdict or indictment in any cause pending or about to be brought before him, otherwise than in the regular course of proceedings in the trial. And to constitute the offense of jury tampering, the influencing or attempt to influence the juror must be either for a corrupt or fraudulent purpose, or by violence or force, by threats, whether indirect or whether direct or indirect. Whoever commits the crime of jury tampering in a civil case is fined not more than $5,000 or imprisoned with or without hard labor for not more than 5 years or both.
Oh, good old Louisiana.
Gotta love Louisiana. Send some people to hard labor. So what this essentially is saying is if you communicate or direct someone else to communicate with a juror with the intent of influencing how they vote on a case, it is a crime. And so that is the crime of jury tampering. Now, jury consultants, which are now referred to more as trial consultants for apparently PR reasons, is what Gene Hackman is ostensibly portraying in the film. He simultaneously goes well beyond what trial or jury consultants do and does far less than what trial consultants do.
I just want you to tell me why I need a jury consultant.
Fitch's team will be scientifically picking jurors predisposed in his favor by using video surveillance, wiretaps, psych profiles, graphology.
Barry, where's my car?
It's where you parked it.
All right, come on, we're going together.
Sir, I have a master's in psychology from the University of Chicago. I know handwriting analysis. I know this stuff. I really do.
So trial consultants are hired by lawyers to help them strategize in their case. And it can happen at 3 different stages of a case. Well, really 4. There's the pretrial period, and then there is the jury selection process specifically. Then there is trial and post-trial. Those are sort of the 4 different phases. And then the sort of activities, the services that they provide that fall into those phases are pretty varied. In the pretrial period, they can go in to the jurisdiction where the trial that they've been hired to assist with is taking place, and do a survey of the community to kind of gauge the public's attitude toward the defendant, the crime in question, or the lawsuit in question, the cause of action. And then they can use that to guide them in their jury selection process. They can also then turn to doing what are called change of venue studies, which from what reading I was able to do in preparation for this appears to be helping to determine whether or not a motion for a change of venue would be helpful or even necessary for a case.
Or in some cases, Jeff, it's like a multi-district litigation, which is throughout the country on different courts.
Oh, definitely.
They try to figure out what's the first one that they should go to in order to try to set the tone. So that's also helpful too.
And I should say what a change of venue is. When you have particularly in a criminal trial, the venue is where the trial is held. It might be, for instance, the Federal District Court for New Jersey has, I believe, 3 venues. There's a Camden venue, a New Brunswick venue, and a Newark venue. Those are 3 different courthouses that all constitute the same abstract court within New Jersey. And each of those is a different venue. So if a criminal defendant, let's say in the Camden, in the Camden venue's jurisdiction is maybe too well known, then or the case has been too highly publicized in that area, so it's going to be difficult to find somebody who is impartial. A defense attorney may move for a change of venue to Newark or New Brunswick because perhaps the news has not really proliferated there, or they're just simply not known in those areas. And so that can be, at times, even necessary to have an impartial jury. So trial consultants do studies to see whether or not a different venue would be favorable, and it's kind of up to the attorney to make the argument for why it would be needed. But that's all in the pretrial services phase. Then once jury selection, once voir dire is approaching, they help attorneys by drafting voir dire questions. These are the questions that are going to be asked of potential jurors, in order to kind of divine whether or not they are going to be biased in one way or another toward the defendant or the prosecution or the plaintiff in a civil case, and also assist with voir dire strategy. What demographics of people within permissible bounds do you want to avoid having on your jury? Is this a case where it behooves you to have more, low income jurors, or is it better to have people who have had negative interactions with law enforcement, or things like that?
Certain people in certain professions are more likely to be, swayed one way or another, or leaders, or so on and so forth. So yeah, there's a whole thing.
little tangent. We're all attorneys. Have either of you ever served on a jury?
No, never happened. Occasionally I've gotten summons and I got dismissed the night before.
Okay.
Before I went to law school, I was placed on a jury in Utica, but it got pled out prior to us ever actually starting trial. In fact, literally the first day, you saw the defendant and he had that moment of like, nope, get me out of here. And
oh, interesting.
So I was on a jury, but never actually heard anything.
I got a summons for jury duty to serve over a period, and right in the middle of that period, I was moving to New Jersey for law school. So I called at the courthouse, and they were like, "Yeah, you're good to go. Don't worry about it."
Yeah.
So that's nice. I also got a summons in Virginia, and called them and said, I'm a civil rights attorney. I sometimes have to travel for things. And they said, there's if you're an attorney, there's a box you can check. And it basically opts you out because they don't want attorneys on juries.
I've heard this before. I always think it's a weird choice that like attorneys are somehow ineligible for this.
Well, they're not ineligible. They're just...
I understand, but you could opt out just by being an attorney.
I don't like that at all, to be perfectly honest. I mean,
I would love to sit on a jury. I think we've talked about this a bit before.
Yeah,
but...
if it fit with the rest of my life, yes. There are occasionally times where I cannot imagine, I'm taking 2 weeks off for work to go be on a jury.
That was why I was actually excited to be on the jury before law school. I kind of wanted to see what it was like before I went.
Yes.
That was the chance. I think until I'm retired, I don't think I have a chance anymore.
Yeah. And especially, I get it. I get why an attorney presenting a case doesn't want another attorney on a jury, second guessing them or speculating as to what they're talking about during a sidebar with the judge or things like that. I get it.
I get it's a genre, but we all know very few attorneys actually go to court, right? So there's a lot of attorneys out there who would be good, they would be good jurors who wouldn't be doing that, and maybe work in-house or not even practicing lawyers who would be able to take the time off to do it if they had to, right? So
I think there's still the fear that if you're on the jury and they know you're a lawyer, the other jurors might ask you legal questions, which your opinion should not, you are not the one telling them what the law is. The court should be telling them what the law is.
Yeah.
Yeah.
And that's actually a really good point. It is, we've talked about opening statements and closing arguments a lot, and we're well off the topic here, but it is the job of the judge to tell the jury what the law is. The attorneys for both sides come together and lay out a set of jury instructions that basically lay down what the law says for the judge to communicate to the jury. So it's
I'll actually get into instructions a little bit in the damages part.
Oh, okay.
Yeah.
Great. Well, we'll talk more about that in a bit.
Yes.
So that's a long digression from the jury selection process itself. Then there is the then there are post-selection services. And these can include assisting attorneys, sort of counseling attorneys on how best to frame their theory of the case, how to best present evidence in a way that this specific jury will find receptive. They also have something called, they do witness prep, and then something called shadow jury services, which sounds very nefarious, but is actually, as far as I can tell, fairly banal. They have one or more panels of random people to sort of serve as the same kind of thing as when there's a State of the Union address and they have people with the dials that are saying whether they like what's being said or dislike what's being said. Essentially, they have a couple, one or more fake juries that are hearing the same stuff, and they're studying their reactions to the arguments being presented, to the witnesses' testimony, and then they provide feedback to the attorneys so they can adjust their strategy, which is interesting. Then there are some post-trial services. Sometimes this involves where the jurors are not anonymous, interviewing them about their deliberations and things like that, to sort of do a post-mortem after a case. Interestingly, I found an article and that broke down sort of how prevalent all these different services are. And I will say that this is an article from 1999, so this data is old enough that it could not be on its parents' insurance anymore. But by far the most prevalent form of service provided by trial consultants is what I called case theory counseling, case theory and evidence presentation services. After that, it's drafting questions for voir dire, then witness preparation, then those change of venue studies that I talked about. Then very rarely they'll provide what I mentioned at the beginning, community attitude surveys, because they're really expensive to do a survey. And by far the least prevalent is the shadow jury services, because you essentially have to employ at least 12 people in addition to your normal team to sit and watch a trial, to essentially serve jury duty without being on an actual jury, which would be an odd experience.
That it seems like the kind of thing that, like, if Microsoft is getting sued for antitrust, they might do, because they have an infinite, like...
Oh, absolutely. Yeah.
For them, like, oh yeah, we'll spend an extra $1 million to do that because it increases our chance of winning by a fraction of a percent. Sure.
Yeah, and those are the kinds of litigation also that are going on for so long that you have plenty of time to do a community attitude survey, and all those other things. And Microsoft, like you said, has the money to pay for these. There's for 26 years there has been debate, well, longer than that. There's been a debate about the propriety of having trial consultants that essentially are, assisting whoever is the highest bidder. Interestingly, the data seems to indicate that their services only have an impact on 5 to 10% shifting a jury one way or the other, which is significant. It is statistically significant, but may in many cases not be enough to actually change a verdict.
The stories I've heard of when people have hired jury consultants and the advice that they gave, it's the kind of thing that I'm like, I cannot imagine spending money on this advice. This seems like it's hiring. To me, it sounded like hiring an astrologer to help you win a trial. What are you doing?
Yeah.
But I've also never worked on litigation big enough to justify having a shadow jury. So
I think they are helpful in sort of, listen, they can be helpful in many situations. They're certainly helpful when there's a very big amount of money and it's a bet the company litigation or a $1 billion litigation where, like you said, like a Microsoft or a huge company is getting sued. And if they lose, it's a problem. It would be an insane amount of money. Yeah, of course they're going to try to do as much as they can. And even if the jury consultant sort of is just a secondary, tertiary member of the team, all they need to provide is a few extra things that might help them, and they're willing to take the 0.5% better chance, right? I think jury consultants are also very helpful when you have a very small trial team and it's a big litigation. So I actually interviewed back in the day prior to starting my own firm. I actually interviewed for a trial consulting firm. Fun fact, didn't go there because hadn't talked about it till now. So shocking. However, I had a bunch of interviews there and got a little bit of sort of an inside look in how they work. And some of the people they work with are very small firms that when they do go to litigation, they need extra help and they would rather not have a lawyer. They want someone who's able to do, focus groups and trial technology and stuff like that. They're basically a very, very smart paralegal who is coming in and making you better, right? That's the way I think about it.
And that makes sense. And it's probably cheaper than having a full-time employee doing it.
Correct. Exactly.
We're hiring you for the 2 months that we need you.
And they're very good with like demonstrative aids, witness. They can even be good for witness prep, because some of them might actually be lawyers, or if they're not, they know what they're doing, right?
Yeah.
So according to this article's statistics, and I'll say the version of the article I was able to download from LexisNexis did not have any of the tables of data that the article refers to. It just said see original, and I don't have access to the original, so that's not helpful. However, I can pass along at least what was in the text of the article, which was that the majority of these, or I guess at least the plurality of jury consultants, are psychologists, have PhDs in psychology. After that,
Right.
attorneys, and then people with a background in like marketing and advertising, those kinds of things, specifically for, whether it's witness prep or how to best present this information to a jury so that it's powerful and understandable, and these are all, useful things for an attorney, really valuable things for an attorney to have, because speaking as an attorney, we don't always have the best instinct as to how non-attorneys will like digest information. We're really bad at that.
I mean, in fact, that's why the best trial lawyers are able to do that. To take relatively complex legal theories with, complex facts and be able to boil it down to, if it doesn't fit, you must acquit. Like, those are the things that will make, they make their careers off that.
Yeah. And having said, what some of their qualifications are, this is an industry that is largely or perhaps entirely unregulated. According to this data, which is, again, over 25 years old, the range of ages for jury consultants was from 18 to 75. So I don't know what background an 18-year-old is going to have in jury consulting, unless you do have, one of
that's a mind-blowing,
disproportionately young jury.
I mean,
yeah.
Okay.
Again, I can't imagine a scenario where I would ever hire anyone who is, not 25 plus at least, but, to each their own. And by the way, the 18-year-old may be very cheap. Who the heck knows? And they might be able to use them for certain reasons.
I'm imagining it's somebody's kid that they're giving a job. That's all I can.
It's possible.
Just need a warm body.
You never know.
Quite possibly, yeah. So what we see in the movie is Gene Hackman's character coming in seemingly like the day before voir dire begins.
30 years in the trenches have taught me this. There's always a loose end. Everybody has a secret they don't want you to find. Find it. First group, Miss Monroe, Ricky Coleman, Sylvie DeShazo, Vanessa Lembeck. Mr. Klein, Herman Grimes, Millie Dupree, Eddie Weiss. Mr. Garson, Lorene Duke, Lonnie Shaver, Frank Herrera. Mr. Lamb, the three alternates. Lydia Dietz, yoga teacher, Philip Seville, shrimp fisherman, Henry Vu. Let's find out everything we don't know. Mr. Doyle, you know the city better than anyone. You take Jerry Fernandez, Stella Hewlett, Nicholas Easter. These are your babies, people. This is what you live for.
So they are not doing any of the, there's no community attitude survey happening here, even though the gun industry has clearly, as shown in the movie, has tons of money, and this case would have been developing for quite a long time. He would not have been doing any change of venue studies. So there's no pretrial services that he's doing. His focus seems to be entirely on the selection process, and he hasn't even done any of the he's not drafted the voir dire questions, it seems, or helped with voir dire strategy. He and his team are just at that moment looking at the jury, looking at the prospective jury members cold and just on the fly trying to decide whether or not they're favorable or not. And the degree to which they are doing real-time research into individuals' backgrounds in a movie that came out in 2003 is a little stunning.
Yeah.
Might be a bit different now. You could quickly Google someone's Facebook page, Twitter account, what have you, and get a fair amount of information.
They were on their MySpaces? Does MySpace exist in 2003?
Not in 2003. I don't think so. I thought MySpace started in 2005. I could be wrong. Yeah, maybe Friendster, but I doubt most juries are not going to be filled with people who are on social media in 2003.
2002 for Friendster. 2003 for MySpace. They could have been on MySpace.
Oh, they could have been on MySpace. Good call. Good call.
They all were all first joiners of MySpace in August 2003.
Okay. Now I'll mention, and I could have mentioned this in the summary and I forgot, but in the book, it's not the gun lobby, it is tobacco, because the husband died of lung cancer. And I felt like that was relevant here for a reason, but now that reason has vanished from my mind, so we'll move on. Gene Hackman isn't providing, it seems, any of the services that are actually generally provided by trial consultants. What he is doing, for the most part, what he and his team are doing, is just straight up jury tampering.
Gentlemen, trials are too important to be left up to juries.
So let's kind of break down what all they do to the jurors. We have at least one instance there. I can't remember if they showed another. At least one instance of breaking and entering to search John Cusack's character's apartment and find out whatever about him. They then set his apartment on fire. A number of jurors are vaguely threatened with like IRS audits and heightened scrutiny of their behavior. I think one woman is threatened with disclosure of the fact that she had an abortion.
Ricky Coleman's boyfriend's name is Neil Pollard. Mrs. Coleman broke it off with him 2 months after the abortion.
The voice is going to help Daddy.
The good news is Mr. Coleman has racked up 3 cases of domestic battery, and there's no way she would have cried on his shoulder about it.
Your husband looks a lot different than your boyfriend with you at the clinic. We'll be in touch.
All of these are communications intended to influence a juror in their vote, or in just getting off the jury entirely. So that is, that is numerous counts, and every communication with a juror is a new count of jury tampering, I believe. So what's interesting is that the punishment monetarily is capped at $5,000 per instance. So for the tobacco company, it's odd to me that number is so low. Because it could be quite cost effective to just eat the punishment.
You're gonna have $100 million verdict against you, yeah. You gamble
right.
for the. There's only 12 of them. I can pressure all 12, and it only costs me $60,000.
Right, you pressure all 12 once,
and it's $60,000 versus.
And you're on the hook for.
You would risk that. Are there criminal penalties?
Well, no, those are that is the.
There's no. Wow, okay.
Well, there's not more than 5 years in prison, or with or without hard labor.
Okay,
so
well that seems more than $60,000, and also your whole team is going to be in jail for 5 years is the more important part.
Sure, yeah, but the company will live on.
I mean,
the degree to which
it depends on who knew about it, but like if your whole C-suite is being sent to 5 years of prison, that's a. Now maybe
sure.
There's. I guess you couldn't do attorney-client privilege because it's, conspiring to commit criminal acts.
I'm just thinking in terms of, in organized crime, the degree to which it is commonplace for someone lower down to take the fall and
also
prove their
genuinely. I doubt the whole C-suite would know about something like that. It probably would be like.
Yeah, probably. This all seems to be done in smoke-filled rooms by just the CEO,
or speculating about a hypothetical crime kind of thing.
Or something. We have what we see in the movie, which is weirdly a bunch of executives all conspiring together to influence this case against just one of them. Obviously, because they don't want to set a precedent of a gun company being held liable.
Or we could focus on the number 1. Because 1 is all they want. One win, one precedent. Because once they get that, they're going to be traveling around this country filing civil actions and siphoning away at that $2 billion you gentlemen sell in firearms and ammo every fiscal year. $2 billion! Woo! Where I come from, that's a lot of money. What I'm asking for is a pittance compared to what a negative verdict is going to cost you.
My share price is down 25%, just on word of this trial.
I'm down almost 30.
Well, I'll kick in an extra 1.5, but no mas.
1.5 each, that's 7.5 total.
Well, I'll take it.
You have any additional plans for this pittance?
Matter of fact, I do.
But all of these are crimes. Notably, so is some of what John Cusack is doing.
Yes, a lot of what he's
absolutely. Yeah, Rachel Weisz's character, who is approaching both attorneys to solicit funds, to solicit money to have them sway the jury from the inside, is also jury tampering.
Jeremy Piven's character might also be doing it. Isn't it implied that he was trying to get on the jury also?
He wasn't trying to get on the jury. He was hired to be I almost said Dennis Hopper, Dustin Hoffman's character's jury consultant. But he also does go to John Cusack's apartment, or his apartment building.
Did I imagine this wasn't... didn't they also imply he was trying to get on the jury also?
If they were, I didn't catch it. I'm not saying it didn't happen. I just didn't catch it. One last thing I wanted to note is that there is an additional statute in Louisiana for jury misconduct, which includes when a juror shall use or consume any beverage of low or high alcoholic content during the time he is in actual service as a juror. So we did see one juror doing that without John Cusack's prompting. He kind of exposes her for drinking while in the jury room.
It's mine, sir.
Didn't take you for a day drinker, Mr. Easter.
I'm usually not.
You still trying to get off my jury, is that it?
Your Honor, I took an oath to do my level best, and I meant it.
Difficult as that is to believe, Mr. Easter, it's even more difficult to believe this is your liquor. I might be wrong, but I don't think that's your shade of lipstick. Miss Hulick? And moving into Miss Hulick's spot will be first alternate Miss Lydia Dietz. Miss Dietz, would you join the jurors in the box, please? Welcome to our jury. I trust you got this.
I'll also add that any juror who accepts or offers to accept anything of apparent present or prospective value for their, any pettit juror who accepts or offers to accept anything of apparent or prospective value before he is discharged from his services as a juror, for his interpretation, impression, analysis, narrative, verbal or written, regarding any element of the criminal trial or jury deliberations is jury misconduct. There's at least a little bit of that with what John Cusack is doing. He's conspiring with Rachel Weisz to obtain money for... I'm not sure if it would fall under like interpretation or analysis or narrative. I feel like what he's doing falls within something in there. I'd have to do more in-depth research to know for sure. But I wanted to mention that. And whoever commits the crime of jury misconduct, either the one who was drinking or John Cusack's character, shall be fined not more than $500 or imprisoned not more than 6 months or both. So that is a rather long dive into jury tampering and jury consultants.
I want to throw in one more thing.
Yeah.
In Louisiana, and most jurisdictions probably have this, you have to be in a county or a parish for a year before you can serve on the jury to prevent the John Cusack thing from happening.
Oh.
And that, I don't think they state exactly how long he was there, but they do say he kind of just appeared out of nowhere.
And that's sweet. Nicholas Easter, our song and dance man, has an agenda. Mr. Lamb, how did this confidence man crash my jury pool?
I don't know. I'd need some time, sir.
Now, I'm asking for an educated guess.
Maybe he just did it. I mean, who wants jury duty? Nobody, right? It's like going to the dentist. It's worse than going to the dentist. It's a municipal database that nobody would ever want to hack into. The security protocol is weak, so you put a name on the list. He may even have increased his
I got it,
chances.
Mr. Lamb. Thank you. Mr. Doyle?
I'm on it.
And that sort of solves... It removes him from the plot, essentially.
Yeah, that would, I think. By the way, for background, John Cusack and Rachel Weisz's characters were students at a school where there was a shooting, and Gene Hackman's character came in on that trial to be a jury consultant, and this is their retribution.
Revenge.
They're going to appeal the gun company. You know that, right?
Of course. Not with you.
You show up in another case, any case, even a contested parking ticket, this gets faxed to the IRS.
And the Justice Department, Federal Board of Judicial Review, you're out. Retired as of today. Gardner, Indiana.
School shooting.
He remembers.
Blackwell Arms. The town really thought they had that one, didn't they?
We did have it.
Now what? What on earth are you going to do with all that money, huh? $15 million, that changes people.
Yeah, well, that's what we're hoping.
Extorting $15 million from him.
Yeah.
And then to sway the jury his way, and then not doing that, doing the exact opposite.
I guess...
Yeah.
Spoiler alert. Dig into this a little bit more. If somebody came to you with that offer, we'll give you the trial, we'll give you the victory in the trial of your life for this amount of money. The thing that both of them should have done, both sides should have done, is immediately report that, or at least as soon as they realized it was a real thing, instead of just somebody crank calling them. And B, like obviously you do that for the moral reasons, for the ethic reasons, but also like what happens at the very end when they are then blackmailing him and saying you're going to retire or we're going to do this. Like, that was entirely foreseeable. Like, if you...
Yeah.
They own you now. You're committing a real crime, and they're the ones with proof. Like, they own you forever. As soon as they did the Pledge of Allegiance scene, which is like 2 scenes later, it's like, oh yeah, you now know it's real. It's not a crank call. You have to, like, behave as if you're, your whole... Everything's at risk now. So, like... And for the gun lobby, it's easy. Like, that they have the money to go and have a mistrial. It benefits them. You can make the argument for the plaintiff. It's more difficult because, like, do they have the money to keep that going? And that's a difficult thing. But, like, the gun lobby doesn't care about that. They should if anything, it benefits them to, like, oh yeah, let's have a mistrial. We'll be back here in 6 months. Great.
Yeah, and I will say there was a case involving an uncle and nephew. Where I believe the nephew was charged with a crime, and the two of them conspired to attempt to influence the jury. They contacted some or all members of the jury to try and sway them, and all of the jurors reported the contact to the judge, and they were both ultimately convicted of jury tampering.
That also kind of gives me hope when it's like, oh yes, everyone saw through this, and immediately it didn't even work a little bit. It didn't work on even one person.
Nope. Now, I will mention that jury trial consultants, while there is a great deal of, let's say, I hesitate to say pseudoscience, but there's a great deal of hand waving about whether or not what they do is backed up by data and evidence. It does seem that in a case between MCI and AT&T in the 1980s, they helped MCI receive a $10 billion verdict against AT&T, which I think maybe up until the Alex Jones trial was the largest verdict for anything ever at that point. And interestingly, the first instance of trial consultants or jury consultants being used was in the 70s by defense attorneys defending.
The tobacco settlement was $206 billion. That's maybe the biggest ever.
Okay, that may have been after this article that I read was published. That's okay. Thank you for the correction.
I like how Mike is fact-checking you in real life on our podcast.
Sorry.
This is actually kind of fun.
Sorry.
Yeah.
That's fine. I just got off a plane, which was where I did a lot of this research.
I also like how Mike is so excited to be fact-checking right now. This is not normal Mike. Normally, Mike is looking up the most insane stat you've ever seen in your whole entire life. Like that's.
I have fewer references this episode because I don't know. This movie did not inspire me. I do have a couple.
And I'm sure we'll get there, Mike.
Yeah.
So the jury consultants were first, as far as I could tell, used in a by the defense team in defense of anti-war protesters in the 70s. So it's interesting that they have gone from being sort of helping the little guy against the state's prosecution of them to a massive industry, largely helping corporations in whatever legal battles they're involved in. Kind of a bummer, but what are you going to do? They've got the money. Speaking of money, let's talk about gun litigation.
Oh, we're going to me? Okay.
I mean,
I didn't know.
It's actually kind of funny because I'm doing damages, so both are about money, just different.
All right.
Yeah.
Yeah.
Oh, that's true.
Yeah,
that was a terrible segue.
Right,
in
so,
fact, it was a much better segue for me, but we're actually going to you, Mike. So here we are.
All right. As we all know, time is a flat circle.
Oh no,
Derek, you get that reference?
This is going to be another
right.
fun.
While I was watching this and doing the research on the gun litigation involved, all I could think about is we've seen this all before. And a bit, he's pulling out the Macallan.
Derek's breaking out the blue box.
So the book is about litigation involving tobacco and dying from tobacco-related illnesses. And there was a whole trend of trying to sue the tobacco industry and tie them to this to kind of put their... You want to get the money. You want to go after the guy who has the money. And the same thing has been going on for years with the gun lobby, and to varying degrees of success and things that have changed in the legal landscape relating to that. So relatively recently, there was a big settlement involving Remington and the Sandy Hook family and the Sandy Hook families. $73 million in the settlement. And this is... Now that was in Connecticut, some different state laws involved, but also a federal law, so in 2000, this movie came out in 2003. It's based on a book from 1996. But in 2005, essentially in response to people trying to sue gun companies in similar litigation, Congress enacted the Protection of Lawful Commerce in Arms Act, the PLCAA. Rolls right off the tongue, which is pretty robust protection from gun-related litigation, and it's a 3-sentence act, so I'm just going to read it to you real quick. A qualified civil liability action may not be brought in any federal or state court, and then B, a qualified civil liability action that is pending on October 26, 2005 shall be immediately dismissed by the court in which the action was brought or is currently pending. And what is a qualified civil liability action? It's like pretty much any lawsuit like the one that we're seeing. There are a couple of exceptions, and we'll get to those in a moment. But it's a pretty robust law protecting the gun lobby, gives them qualified immunity essentially, and it was written by the NRA. And the NRA specifically has protection in this law, so you couldn't sue the NRA also. Why do I say time is a flat circle? Is right around this time, people were trying to sue the gun lobby for essentially these same things. It's been going on since then. The way that the plaintiffs got around it in the Sandy Hook trial is one of the exceptions. Among the exceptions, A qualified civil liability action is a lawsuit against a gun maker, seller, or trade group. The trade group, in fact, refers to the NRA for harm caused by criminal misuse of a gun. So the 6 exceptions are: the seller was convicted of illegally selling a gun, the seller negligently entrusted a gun to someone dangerous, or broke a safety law. This is my rewriting of the law itself. I don't want to read the whole statute. If the manufacturer or seller broke a specific gun law that helped cause the harm, like falsifying records or selling to a known prohibited buyer. If it's a breach of contract or warranty related to the gun, if the harm was caused by a defect of the gun's design or manufacture, criminal act, or if the U.S. attorney generally brings a case to enforce gun laws. If you guys could guess, which of those do you think that the Connecticut plaintiffs used to get around the gun laws?
Something about if the harm was caused by a defect in the gun's design or manufacture is sticking in my brain.
It's a bit of a trick question because it is.
Because I thought Sandy Hook, I know a little bit about it. I thought they didn't actually go base it upon that. I thought they went in a different direction, right, to get around it.
So they had to get around it, and
they went unfair trade practices, didn't they?
Yep, exactly.
Yeah.
So it's whenever the manufacturer or seller of a qualified product knowingly violated a state or federal statute applicable to sale or marketing of the product, and the violation was approximate cause of harm for which relief is sought, and then enumerate some other related parts. So they use the I guess it was the Connecticut Fair Trade Practices Act, or let me make sure I have this correct.
Yeah, it's the CUTPA.
There we go. And they use the marketing material that the gun manufacturers were using because they were targeting essentially at least allegedly they were targeting at-risk men who with like the ads were like get your man card back, and like putting the specific gun that was used in the shooting in like advertisements or in video games. They were essentially targeting at-risk men, trying to sell them these guns. The gun companies filed a motion to dismiss. It survived the motion to dismiss, and as it was going to discovery is when they settled for $73 million. It was a clever way to get around it, and honestly, I was like, I could understand finding another way, because the law is a pretty robust defense. Unfortunately, in our case, there's an even more robust defense because in 1999, Louisiana passed the Louisiana Revised Statute, I'm not going to read the number, which limits liability of firearm manufacturers and sellers. This law states manufacturers and sellers are not liable for injuries, damages, or deaths resulting from criminal or unlawful use of the products, provided the firearms were legally sold and not defective. Makes it much harder to get around. So it's unless the gun explodes in your hand, or they knowingly are selling it to, someone who's not allowed to have it, or someone who's like knowingly going like, can I buy your gun to shoot this man in the head? Like, there's very few ways around this. That said, so would this have worked in this case? Like, this case takes place in presumably 2003, because that's when the movie came out. The Louisiana law is in effect. The PLACC is not in effect. Would this have worked? It's a little bit unclear because I want to get your opinion on this. They mention a couple random facts, but I couldn't figure out exactly what's going on when they're really pressing the gun salesman. Like, why were you selling to somebody who bought so many guns?
Good afternoon, Mr. Murphy. You own and operate Excalibur Guns.
Yes, sir, I do.
Yes, and isn't Excalibur Guns a retail outlet store for Vicksburg firearms?
Yes, sir.
Would you tell us about your arrangement with a man, Michael Kincaid, who illegally sold this Performer 990 semi-automatic to Kevin Peltier smack dab out of the trunk of his car?
My arrangement?
Yes, sir.
Well, Mikey, Mr. Kincaid bought guns from my store.
At a rate of more than 25 guns a month. Didn't you ever wonder who your friend Mikey was turning around and selling these guns to?
Well, that's none of my business.
Oh, you mean it's not your problem?
Now, hold on there. I didn't say that.
That doesn't seem relevant unless this is an intermediary that they're selling it to. Like, they're knowingly selling it to somebody on the black market. Like, they never say that the gun was bought legally. At least I don't remember them saying that. Maybe it was. And I missed that. I've only seen the movie once. But if they're saying that, oh, you, the gun seller, you whatever this gun company, the stand-in for whatever the gun company is, was selling it to people knowing that they were going to resell it on the black market. You're selling it to somebody who's buying 100 guns a month, and they're buying the exact same gun, and they're not a licensed gun seller. And then the gun was later bought by somebody bought by somebody who would not have been allowed to buy a gun otherwise, and then proceeded to kill someone. That might be a way around it. It's just not clear. Was the gun bought legally? Are they implying that the gun company was knowingly selling on the black market? There's a couple moments that hint at that, and it's not quite stated clearly, or at least I didn't catch it. The other thing that I thought was interesting is they also went to the advertisements, which is why I was saying time is a flat circle. They're like, oh yeah, like the fingerprint thing. It's fingerprint resistant, which you would only need if you're selling to criminals.
Now, Mr. Janko.
Yes, sir.
The ad copy used to sell the Performer 990. Would you read it to the court, please?
It's right there, Counselor.
Oh, but I think that the jury would like to hear it from the head of the company here. If you can see it starting with also available in.
Also available in a print-resistant finish.
I see. Now, who in your mind, sir, might be eager to purchase a Performer 990 semi-automatic assault-type weapon in a fingerprint-resistant finish?
Anybody.
Anybody.
Fingerprints are 90% water. Water corrodes metal. Metal rust.
Wouldn't it be more appropriate then to use the words rust-proof than fingerprint-resistant when you're trying to sell this weapon to the general public?
Well, I didn't write the copy for that advertisement, sir. I think you know that.
Did you see it?
Which is actually a point in their favor. Like, they're knowingly selling to criminals. They're advertising it to criminals, presumably.
Sure.
It's just not quite enough. It's not quite there for me to know. And I don't think they ever quite stated their claim enough. There's
Sure, there just isn't enough that was shown in the movie to say.
That's what I'm stuck on. I do appreciate that it is like, and there were a bunch of these lawsuits in the 90s and early 2000s of people trying to sue gun manufacturers the same way they tried to sue Big Tobacco, and some varying degrees of success. They were all mostly flattened by the federal law until recently, and I don't know if they've had more success in Sandy Hook, but that was sort of the biggest case in, that was 2022 probably that came out.
We've had a few asides mentioning alcohol a couple times this episode. Has there been any similar kind of litigation against
big alcohol? That's a great question. Yeah,
breweries.
I don't know. That's not a thing I was looking into, but yeah, that's
because I know that in instances of like vehicular manslaughter or things like that, when someone has been killed by a drunk driver, people have tried to hold bartenders who served them when they were clearly already past the legal limit. They've tried to hold bartenders accountable, but I've never heard of anybody trying to hold
I'm sure somebody has tried, and obviously, like you want to go for the big pockets. Like that's why all these. Why is anyone suing?
That's why you go for the restaurant.
Yeah. Why are people suing Big Tobacco? It's like, well, Big Tobacco has more money than the gas station that I bought the cigarettes at.
Yeah, the only thing I'm aware of with like spirit manufacturers is typically like misleading labeling, stuff like that.
Yeah,
it's rarely is it directly for like something like that. And I think it's, and again, I guess there could be like a wrongful death, and it depends upon how it was. If it's the labeling that did something that would have caused someone to drink it or blah blah blah. But that's usually why they go after the restaurant or the bar themselves, is because they kept serving someone who was clearly, legally. Not only legally drunk, but also probably further than that, right?
Yeah.
Yes.
Yeah. Far gone.
Yeah.
We'll just say. And there was actually, going back to the unfair trade practices, there was a lawsuit against, I believe it was Coors, for claiming that the water they used was from the Rockies.
Oh yeah, I remember this.
Just like municipal water from wherever their factory was. Yeah.
Yeah.
Anyway,
that was pretty much all I had on my own. They're suing for gross negligence in the movie, but I didn't really. Do you guys want to go over that, or not really worth?
The one thing I'll say about gross negligence, which might be how they get away from it, is most states, and granted, I don't know how it works when there's a different statute that's sort of on point regarding going up against the gun manufacturers, but typically you cannot contract your way out of gross negligence.
Yeah.
So like, and for the listener who's not familiar with how that works, gross negligence is basically one level above negligence, where you're like intentionally or recklessly causing, whatever the harm is. And
maybe that leans into the fact that they were selling it on the black market or something, where it's like, oh yeah, you were knowingly selling this to people who, like, no one's buying it on the black market if they can buy it legally. So you're selling it to people who are doing this for criminal purposes.
Right. Yeah,
which might be true. Yeah,
and it's possible that's how they get around it. But again, I don't know Louisiana statutes well enough to be able to figure out if gross negligence changes that. But I got to assume, and listen, I don't know much about the statute. I got to assume if they intentionally did something that caused it to get into the hands of a criminal or something, like, that can't be allowed.
That's the one one of the two exceptions under Louisiana. So that would get you through both of them.
Fair enough.
Hi everyone, Derek here with a brief message. The Not So Grand Jury is sponsored by my law firm, Moriwah P. LLC. One of Moriwah PLC's many practice areas is business law. If you are a business owner or someone who is thinking of starting up a new or side business, you need a legal team who can efficiently provide you legal counsel, keeping you and your business away from potential legal issues, and if necessary, representing you in any disputes that do arise. We pride ourselves on being cost efficient while also getting to know our clients. If you want less stress and more support, you need Moriwah. If you would like to set up a free consult, please click on the link in the show notes, visit our website, www.mooreatty.com, that's mooreatty.com, or email us at contact@mooreatty.com. And now, back to the show.
All right, Derek, you want to talk more about money?
So I'm going to actually talk about the money that Jeff had segued to you for. Now we're segueing to me. So I'm going to talk about the damages in this case. So fun fact, I did not realize this until I started doing research, because I didn't understand what they meant by runaway jury until I realized that a runaway verdict or a runaway jury verdict means when the jury sort of gives an unusually high damages award that's outside of what the typical facts of the case would indicate. So that is in fact what a runaway verdict, runaway jury is. Didn't know that. So good to know that I figured out what the title of the movie meant, since we...
they don't really tell you.
It never really comes up to my knowledge. I'm going to talk about the damages that were requested and ultimately found and awarded to the plaintiff in this case.
This suit is brought by plaintiff Celeste.
Over your left shoulder, Rankin-Fitch, 2 o'clock. Dark suit. You've heard the myth? Now meet the man.
Quaking him before shines. Celeste Wood claims that Vicksburg Firearms is liable for her husband's wrongful death and seeks special damages for loss of Mr. Wood's future earnings, as well as general damages, including pain and suffering. Plaintiff has exercised her right to a jury trial. Ladies and gentlemen, we are now ready to begin the voir dire.
Miss Coleman.
And in the end, when the judge reads the verdict...
The jury finds for the plaintiff, Celeste Wood. They award special damages in the amount of $1 million and general damages in the amount of $110 million.
So let's talk about what these damages mean. There's basically, in the civil litigation context in the United States, there's basically 3 kinds of damages. There are special damages. Those, and it seems weird that special in general, that special is the one I'll talk about first, but special effectively means damages that can be quantified or calculated. So it's economic damages that can be, either calculated or quantified in monetary terms. And the examples are usually medical expenses, lost wages, the amount it would take to repair property damage, the amount of money that if someone breached a contract and you were supposed to receive X profit, that's how much money you get. That's what special damages are. General damages, which are also known as non-economic damages, are where you get compensated for intangible losses, pain, suffering, emotional distress, loss of enjoyment of life, things along that nature. And then there's a third category that was not in the film, but actually was in the book. So I think you guys might be aware. The book actually took on Big Tobacco, not the gun manufacturers. And in that case, they actually awarded punitive damages in the book, which punitive damages are, what are also known as exemplary damages, are designed to punish, hence punitive, the defendant for egregious misconduct and to deter others from committing the behavior. They are not designed to make the injured party whole. That's the purpose of special and general damages. So punitive damages are really to punish. The most common sort of form of punitive damages, at least in my life, is treble damages, where there are some statutes, including a lot of unfair trade practices statutes, which is why I'm a little familiar with what Mike was talking about with Sandy Hook, because in my construction real estate litigation, we tend to use the unfair trade practices statutes to our advantage, and a lot of times they have treble damages as one of the ways of getting damages, which is why we like using it, because treble damages mean effectively that whatever compensatory damages are found, aka special damages, are trebled, in other words, multiplied by 3. So it is a...
Yeah. I don't know why the legal world puts a B instead of a P.
It's not
nothing
triple
to do with
damages,
music.
it's just treble.
It's not related to Latin or something.
It's I don't know what it is, but I find myself saying treble a lot, even when it comes to just trying to say the word 3. So this is where my life has become. Yeah, go
And
for it.
Derek, something in my recollection, states refer to general and special damages differently than, like, one state may consider special damages to be the non-economic harm and general damages to be the
It's
quantifiable
possible.
harms.
Yeah,
and
it's possible.
all very...
I could look up Louisiana just to confirm this is what they do. So I can confirm that this is. I can confirm that this is what Louisiana does. In fact, and I'll talk about it in a second. I did find, in fact, a jury verdict form that I'm going to sort of walk through and sort of explain how we actually. It's not for this case, but it's for a different case in the same.
Oh, it's not for this fictional case. You don't have the jury instructions for this fictional case.
No one actually fictionally came up with a jury form. In fact, I do have one though from a 2017 case in this court. It's the district court for the parish of Orleans, and it's a verdict that was against someone that had both special and general damages. So I'm going to walk through that in a second. But one thing we had talked about earlier on this episode was jury instructions. So I wanted to briefly sort of mention. These guys basically talked about the sort of liability side. There's basically 2 parts to every single case. You have to prove that someone is at fault. Then you have to prove how much they damaged the plaintiff. So you have to first be liable. Right. Wouldn't you find them liable? Then the second question for the jury is, how much were they damaged? Because there have been many cases out there where the jury has said, yep, they are liable. We're awarding damages for $1. Because they just don't think they were ever damaged, right?
Yeah.
So you, as the plaintiff, you have to sort of, get to 2 different levels. So we've already talked about the liability side. Now I'm going to talk about sort of how we get to the damages calculation. So when the jury is sent back to deliberate, prior to that, they get what's called a jury charge or jury instructions, whatever it is. And that's basically where they're told how to act like a jury and deliberate. They are effectively given instructions that explain introduction of the process, like what is a burden of proof. So like, in a civil case, most of the time the standard of proof is just, who basically the preponderance of the evidence, who has the better evidence. If someone is 50.1%, the winner, they win. It will explain legal definitions of, elements of a crime, elements of a claim, and it will explain how to evaluate evidence. But the one thing it will also do, it will include a jury verdict sheet that the jury has to fill out at the end of it. And typically the verdict sheet is going to have 2 parts. It's going to have the liability part, and the liability part is usually pretty straightforward. Was the defendant negligent in causing X? Yes or no? And if you say no, you probably sign the verdict sheet and hand it back, and that's the whole verdict sheet. If they say yes, then you keep going forward to determine if there's multiple defendants, what percentages are they at fault, or if it's just one percentage, how much money did they prove to adequately compensate the defendant? And they will usually have the categories of damages. So in this case, there were 2 categories of damages. There was the special damages, which was the loss of future income of her husband, and then the general damages, which I think they said was, pain and suffering? Yes, including pain and suffering. So in this case, the jury awarded $1 million in special damages and $110 million in general damages. That is a certainly feasible verdict in the grand scheme of things. Like, we didn't hear much evidence. Like, we didn't hear a lot of some of the evidence. We heard, not shockingly, we heard the cool parts, as it were, The parts where the defendant loses his mind, the part where one of the witnesses basically flips on one side, things like that. We don't really hear the full everything. The one thing I will note is normally special damages are calculated at least to like $1, possibly even to the cent. So like usually special damages are like, and in this case, they would say loss of future wages. They would have figured out how much money he would have made per year, possibly up until retirement, done that calculation, and that's the money. It's unlikely that would have been a flat $1 million with no specific amounts. Like the example I'm going to use in the jury verdict form that I'm going to attach to our show notes, it was 55,842 is what they determined, right? Like they did the math and they figured it out to the closest dollar. So in a real case, it is likely the jury would have done that. Now, it doesn't mean in the verdict form they couldn't have done it. They could have said $1 million. And in their head, he would have made $50,000 a year for 20 years, and they said that's $1 million, right? Maybe that's what they did. That is a feasible way of calculating it.
Although, given this guy's job, I think $1 million is probably low.
That's my guess too, but I guess you can take into account retirement age, I don't know.
The important detail is that they wanted the total to be $111 million, so it had to all add up to that.
Correct.
That was
no
without having for them to say the random cents and everything. They wanted it to be $111 million easily.
Yeah, understood. Now the $110 million in general damages, there's probably literally a line item on the verdict form that says like future pain and suffering, or maybe past pain and suffering. So maybe there were two lines. Maybe it was like, how much did she suffer to this point, and how much is she going to suffer in the future? And they told that up to $110 million.
Right.
There's
how
no
How much is your husband worth? How much is her son's dad worth?
Correct.
There
is no such calculation that they needed to do, and I'll again on the verdict form in this other case, there was 6 line items. There was past physical pain and suffering, future physical pain and suffering, past mental anguish, future mental anguish, past loss of enjoyment of life, future loss of enjoyment of life, and everyone was a very round number ranging from $200,000 to $400,000, and it totaled up to about $2 million, give or take. So that certainly could have been the case here, and it is very feasible. They would have said $110 million. That is a lot of money, but it's, maybe to me and you, that doesn't seem terribly off for the loss of, one person. Now, I think it should be possibly more often that happens, but that's a different conversation.
It seems like a high number considering other settlements that I've seen.
Of course.
The Sandy Hook one, we're talking about
of course.
20 kids being murdered was only worth 73 in a settlement, and that's probably the right number.
I guess one clarification is in that case, they actually won $1 billion and then ended up selling for 75 because of the damages cap, right? Wasn't that part, or not the damages cap, like the bankruptcy issues, a bunch of other competing litigations.
Am I getting that mixed up? Because I thought they settled for 73 before it went to trial.
Maybe that's the case. Oh, you want to know what I'm thinking of? I'm thinking of the
Alex Jones,
the Alex Jones trial.
There's a lot of fun litigation that came out of that.
Yeah. So I guess in this case, I'm actually I'm not saying it's realistic. I'm not saying any other case would have been like that, but there's very little other than the fact that they didn't have a special damages award that's appears to have been calculated. That's really the only issue I'm seeing. Everything else seems to be fair. I was a little worried that there might be a cap on damages in Louisiana. There is not for personal injury, which is what this would fall under. So Louisiana does not have a general cap on damages for personal injury cases.
It's almost surprising.
Which
we've discussed this in the past. In the Jaws episode, we talked about how much Miss Kittner could have gotten for the death of her son, and I think that was capped at $200,000.
I did a very quick look at this. I was focused mostly on Louisiana, but it is all over the place across the United States. And I guess the clarification is also there's a difference between general damages caps versus punitive damages caps versus other things. And it really sometimes depends upon the specific statute. There's a statute in New York for certain business unfair trade practices claims where you're allowed to get treble damages, but those treble damages can't be more than $1,000. So it's like there actually isn't treble damages. You can just get an extra $1,000. You can win on a breach of contract claim and then get an extra $1,000 thrown in as a thank you. Like, so every state is very different on these. There are as of it's a late 2024 article that I saw. There's 11 states that cap non-economic damages in just generic tort or personal injury cases. Louisiana is not one of them.
Interestingly, California's civil rights statute is sort of the reverse of that. They have a floor of $4,000 or triple damages, whichever is greater.
That sounds like something California would do. Yeah.
You can imagine other states doing things like that, where there's a minimum amount because you want to, either incentivize certain behaviors at least a little bit.
Yeah, in the civil rights context.
And I will say that the one area that appears that have the most caps is medical malpractice. Apparently, there's a lot of caps, and like over half the states have some type of cap on either medical malpractice claims or like total caps that sort of limit economic and non-economic compensation in those cases. So obviously not the case here, but overall, like honestly, like the damages wasn't as far off, and it was actually interesting. You mentioned before, Jeff, about the general versus special. In my brain, it was the opposite, general and special. So I'm not sure if that is I learned it like that in law school from a different state, but looking it up, that is the correct. And I think it makes sense because general means general. Like there's no specific statute or specific like historical doctrine that gives you the money. Special damages are because they are based upon, either history or court law or statutes. So it makes sense in a weird way, but like you would think it's the opposite just from common sense.
Yeah.
But
all right, that's
all I got.
Pretty much everything.
Did you said you had other fun facts that I'd like to know?
These are not the funnest facts I've ever had. John Cusack appears to work at GameStop.
Yep.
This fits. A buddy of mine had the Hackman Cain theory in college, which was at any time of day. This is 2007 or whatever. Any time of day, there's always a movie with either Gene Hackman or Michael Caine on TV. And this fits pretty nicely in that. At some point, they tell Gene Hackman he should retire, and this is his penultimate movie. He had one other movie after this.
Yeah. Oh, interesting. And by the way, moment of silence for the passing of Gene Hackman.
Incredibly sad. I haven't followed all the details. I know there's a bunch of stuff that keeps coming out about it.
I mean, it's sort of a sad ending. He was 95, but it's a sad ending.
It's sad. Also, his wife was in their 70s or something, right?
Yeah.
Yeah.
Right. His wife and their dog, and just terrible.
This is not the place for it, but the lesson is like, if you have a relative who's getting older, having an aide who can come in and check on everything is good. Like they had the money for it. They should have had a maid or an aide coming in at least a couple times a week to check on them, and that would have solved all the problems. Solved a lot of the problems.
Also, to be perfectly honest, I'm not sure if Gene Hackman passed up a movie he didn't like, because for God's sakes, he did so many movies in the 70s, 80s, and 90s.
Yep. It was him and Nicolas Cage. Just they like working. Really like working.
If one of them wasn't available, the other one was.
Yeah.
He set the bar for Lex Luthor's.
There was also a Superman reference. He was him and Dustin Hoffman, which is this is the only movie they've ever been in together. This is the only time they ever spoke on screen.
Oh.
He has a comment about and you're doing this for truth, justice, and not the American way. And I was they got it in there. Good.
You think your average juror is King Solomon? No. He's a roofer with a mortgage. He wants to go home and sit in his Barca lounger and let the cable TV wash over him. And this man doesn't give a single solitary droplet of shit about truth, justice, or your American way.
So
that is kind of interesting.
So, what'd you all think of the movie? I guess I'm gonna go down my screen. Derek, your verdicts, your votes.
Okay. So here's the interesting part about sort of because I've been thinking about this, and up until right now, I'm still not sure exactly which way I'm going to vote on the legal side, because again, when we're looking at sort of legal reality, the trial was not conducted terribly badly.
Mm.
The voir dire was not conducted terribly badly. I mean, I'm not saying that they would get away with everything they did. We didn't really get into the voir dire actual aspects of it. What they did is completely illegal, impractical, everything else. But I guess the big question is, could they have gotten away with it? You know, it's the gun manufacturers. They're just throwing money at this guy. Like, you know, I'm not saying it was fine. Like, I'm not, you know, but at the same time, could this have happened? Not going to say no. And in fact, a future episode that I am highly at least one episode I'm recommending we do in the future is Bull, which is a show about a trial consultant. And in Bull, he actually has shadow juries every time, which is a lot of fun. So so we'll get into a couple of those. It is much more ridiculous than this in many different. It's like it's the suits of trial consultants.
Shocking.
But anyway, I am, and again, the damages part did fine on. We are a little questioning whether or not they could have actually filed this case in New Orleans and won against a gun manufacturer based on Mike's research. But honestly, I am going to affirm on the law just because I do think, like, again, I think it's ridiculous and I do think multiple people are going to jail, but could it have happened during the trial without, like, it's not like anyone found out that's of, you know, note and looked the other way. It's not like the judge was aware and didn't do anything, you know. All this seemed kind of like it could have theoretically happened in a completely insane scenario. I'm affirming. In terms of enjoyment, I can't believe I'm going to say this phrase. I almost have never said this phrase in my life. I like the book better. I rarely say that. I am not the book was better than the movie guy, but I actually think the book was better than the movie. So I'm going to say no to the actual enjoyment of the movie. I do not plan to watch it again. But that's not to say there wasn't some phenomenal acting in it. Just didn't like how the film came out.
All right. Mike.
I'm in a similar place on the law where it's close and you almost wish we could be a little more granular. The biggest thing about the law is like where does it get the name runaway jury from? And you know, obviously the word itself has meaning, but also like it's because John Cusack and him and his who played his partner in this,
Rachel Weisz,
what they're doing, and that part wouldn't have worked out like that, and that's where I'm kind of stuck. Where like that the crux of the movie is based on a premise that wouldn't have worked out. So I guess I'm gonna say no on that, but they did get it. Actually, they got enough other stuff right that it's very close. I'm gonna say no, but by the narrowest majority. Didn't hate the movie, but it is a very much a John Grisham movie where it's like every plot twist, every plot twist has to have a plot twist, more plot twists. That's how you know it's good writing when there's just plot twists on plot twists. Gene Hackman can act his fucking way out. Like, he's a great actor. Everybody did a good performance. I have no issues with that. I know. Did they shoot on site in New Orleans?
Yeah,
they didn't.
They did a fair amount of it on site. Yeah.
Somehow it still didn't feel super New Orleans-y to me. Like it's somehow the whitest cast possible you could have in a New Orleans-based movie. Didn't hate it. I could watch it again.
They found like the cleanest parts of New Orleans, it seemed like.
Yeah, no, like Bourbon Street smells like vomit every day of its life.
And I will say there's that one. I was actually going to bring this up. There's the one part where they're talking at Cafe Du Monde in the middle of the day. While it's pouring rain. Cafe Du Monde, if it is the middle of the day while it's pouring rain, has 9 million people underneath that freaking canopy. Not just like the two of them and like 9 others. I don't know when. There's not a day in the year where Cafe Du Monde has that few amount of people in it during the day.
It just
okay. So we're overturning on the New Orleans.
Yeah, it didn't feel super. It just didn't feel super New Orleans to me, and I could watch it again if it were on the background, but I'm probably gonna say no on both.
Okay. I agree on some things with what you all are saying. The damages make sense. I'm pleased to see that they used the right terminology for New Orleans or for Louisiana. I think, and Mike, I agree that what the scheme between John Cusack and Rachel Weisz would not have worked for a number of reasons. First of all, because the gun company would have been looking for anything to have a mistrial. And this, I think, certainly would have done it. Especially if, once you've gotten the call and then they've done that Pledge of Allegiance thing, there's no doubt that they are influencing that jury. Like, they just are. And so that is problematic. And I think this was the subject that I focused on in my part of this discussion, but the degree to which the film portrays Gene Hackman's character as what jury consultants do, and it is entirely not what jury consultants do, has me leaning toward no. There are things that I like that they got right, but it is that very John Grisham thing of he's taken a real thing in the legal world and like blown it all out of proportion and changed some fundamental ways about how it works. We've seen this not in this run, but in The Firm and The Rainmaker. So I'm going to vote to overturn on the law. So no on the law. And on entertainment value, I mean, I will watch Dustin Hoffman and Gene Hackman chew some scenery over like 75% of what is, on Netflix.
Yes, the scene with them in the bathroom.
So I'll say yes. Yes on entertainment, and it was interesting seeing some of the. I didn't expect to see Jeremy Piven in this. There were a few members of his team that have gone on to do a lot of other things, and it was entertaining to see them in these different roles. Particularly, I'm blanking on his name, but the one of Gene Hackman's henchmen was later head of the Marshal Service at the courthouse in Justified. And it was interesting to see him playing a bad guy. Anyway, I will affirm on entertainment and reverse on
so it sounds like
the law. So
the inverse of what we're, because of Mike's two reversals, we are reversing on both, as well as New Orleans realism.
Yeah, no, we all agree that
yes.
As well as
I'm happy that they shot it there, or just somehow it doesn't feel New Orleans.
Well, and I recognize Cafe du Monde. I recognize the Supreme Courthouse, even though that's actually not where they would go. But I recognize the courthouse.
But that's gonna happen.
Yeah.
Like,
and John Cusack's machinations to get like the judge is buying them lunch at this expensive restaurant because he like managed to throw a paper bag out of a window while no one noticed so that Rachel Weisz could interfere with the lunch order. Just bizarre.
Well, the whole point of that was to show that something weird's going on. So that way everybody knows something weird is going on with the jury.
Right. Yeah.
Which honestly, like, it just makes it more likely that, like, if there was a mistrial, it would immediately, like, that would probably get referred to the police to investigate, is someone tampering with the jury here? Because that's a weird fucking thing.
Yeah.
And, like, there's a limited pool of people that it could be. Like, your immediate suspects are these 12 people.
Right. Yeah. Okay.
The Not So Grand Jury is sponsored by Morwa PLLC.
The opinions expressed in the Not So Grand Jury are those of the hosts themselves, and not of their respective employers.
The theme music for the Not So Grand Jury is from Gustav Holst's Jupiter and is in the public domain.
If you'd like to get in touch with us, if you want to suggest future movies, or even if you want to offer corrections, you can email us at notsograndjury@gmail.com or message us on any of our social media accounts.
The Not So Grand Jury is copyright 2025, all rights reserved.